you have an obligation to stand by and, supervise all of your staff, the people that you work with on a daily basis who are non-lawyers, right? Well, the same is true with AI. Now we can talk a little bit more about where ethics and morality meet. And, and we'll talk very briefly about some life and death decisions, because ethics and morality tie in very, very well in this particular area. You have to remember that the laws are not ethics. The laws are what society has created in order to impose its moral compass.
My name is Nina, and I'll be the moderator for this webinar. I wanted to start out by giving a bit of background on our speaker, Tom Schack. Thomas Schack leads a highly specialized appellate group that focuses on business and criminal appeals. Tom's extensive background in state and federal courts, and as a former Comptroller of the Commonwealth and a state prosecutor, brings a wealth of knowledge and expertise in legal, financial, and business matters. Tom is sought after for his strategic guidance and deep understanding of business and legal ethics, and as an adjunct professor in business and ethics at his alma mater, New England Law, Boston. He also holds dual JD and MBA degrees. The webinar presentation you're about to watch will be approximately 1 hour, and Tom will be taking audience questions after the presentation is complete. At that time, I will also be providing you with the CLE code that Marina mentioned that you need to get credit, so keep an ear out for that. If you have any questions that come up for Tom during the presentation, please feel free to submit them through that Q&A button in the control panel at the bottom of your screen. Now, without further ado, here is Tom to discuss ethical evolution, thriving at the crossroads of law and business in the AI era.
Thanks, Nina. I am so glad to be here with everybody today. We're going to talk today about the ethical evolution and thriving at the crossroads of law and business in the AI era. When I do these types of presentations, I typically just, they're very kind of conversational, although the one-sided conversational, of course, as a law professor, that's usually the case. But in any event, please, feel free to reach out to me after this. My email's at the bottom of the screen. If you have any questions, concerns, comments, or if you're interested in, chatting about what's happening in Massachusetts or Boston, we are more than happy to accommodate. That said, we are in fact in a new era, and that new era is changing daily relative to the ethics of law and business as it relates to artificial intelligence. So first, we're going to go over a little bit of a primer. This is for the CLE portion, really, but a primer on legal ethics. So we're going to discuss and review several rules, and we're going to bring them into my presentation in a number of different ways today. But the questions that I'm going to be asking, by the way, throughout this, there'll probably be 3 or 4 questions that I ask you to really consider. We're not going to do a poll because it's more beneficial for you to think about what your answer would be to those questions and why. So as we're going through, we're going to be discussing Rule 5.3, Rule 1.1, 1.3, 1.4, 1.5, and 1.6. And remember, this is not a comprehensive review. I mean, this isn't like you're, preparing for the ethics portion of the bar exam. It really is just a reminder and some consideration to take into or to think about as you are interacting and starting to evolve within our new legal AI environment. And again, if you lack any understanding or if you have any questions about that, you're welcome to reach out to me. But also, there's a link on this slide when you receive the slides. It will give you the access to the rules that we're discussing. So that will get started. All right. So first, we're going to talk about Model Rule 5.3, and the reason that we're taking the ABA model rules out of order is that this rule really impacts professionals and particularly legal professionals. And we're starting to see that right at the outset, again, of the use of AI within, practices across the globe, really. So it's very important to understand that under Model Rule 5.3, if an attorney works with a non-attorney to instruct or assist when using an AI tool, the attorney must ensure compliance with ABA Model Rule 5.3, which imposes a duty to supervise non-lawyer assistants. All right, so that's a mouthful, but what does it really mean? It really means that as supervising attorneys, and if you are a supervising attorney, you have an obligation to stand by and supervise all of your staff, the people that you work with on a daily basis who are non-lawyers, right? Well, the same is true with AI. AI is no different. If you're whoever you're going to or whatever you're going to rely upon from a non-attorney or non-barred standpoint, you have to take into consideration this rule. And part of the reason why this is so important is you're starting to see, and we've seen a few kind of early cases of attorneys who have used AI. They've gone, to prepare a motion or a brief. They go into court or submit it to the court, and it turns out that the AI system that they were using actually made up cases. We're still in the Wild West as it relates to that issue. So by all means, just make sure that you understand you are responsible for every single word that you utilize from an AI system. And I would be very, very cautious, and I'd caution you, particularly within your jurisdiction, to figure out what those limitations are, and to make sure that you're not only in compliance with the model rule, but also you're making sure that you're representing to your best interest, or keeping your client's best interest in mind. So, next thing, we're going to talk a little bit. Again, this is as a primer. We're going to talk a little bit today, initially about morality versus ethics, because there's these two often get mixed up, but they're very, very distinct. And for those of you that already understand this, no problem at all. It will be over in just a few minutes. But as it relates to those folks who aren't aware of the difference between morality and ethics, the two are quite distinct. Morality comes from the Latin mores, which usually refers to any aspect of human action, right? So, and typically, morality is doing good with regard to any aspect of human action. On the other hand, ethics comes from the Greek ethos, and also commonly refers to the acts associated with morals. So, sounds a little bit technical, but it's really, pretty simple. And that is that morality is the base on which, if you think of a pyramid, morality is the base of the pyramid, and then ethics, and particularly professional ethics, are layered on top in different ways up to the point where, again, for us as lawyers, we're self-regulated. So there's, very significant implications for us to act immorally, or to not understand that morality is sort of the keystone of ethics. Just to wrap that up, morals define personal character, while ethics stresses social system in which these morals are applied. Now, this is something that I typically use in one of my classes, when I'm teaching law students, but I think it's, I've used it professionally, and I think it really is appropriate here. So we want to think about that. We want to think about the personal character aspects of morality versus the social system or the structure that's put around those morals by the professional association, in our case, by our local bars, our state bars, or the American Bar Association. So moving on to ABA Model Rule 1.1, be competent. That's it sounds like a pretty good idea. And the rule holds the lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Right. So again, if you're thinking about the concept of AI as it relates to this, you have to be very, very cautious about relying upon an incompetent AI source, and there are lots of them. Because I teach and I research in this area, it's really important to understand that, many of the systems that call themselves legal AI are anything but. And a lot of times they've been cobbled together very quickly just to get a product out on their market. So just keep in mind that your thoroughness and preparation includes making sure that the systems that you're going to use, or the AI systems in particular, are going to are going to be checked for competency by you. And again, if I'm signing a document or you're signing a document as an attorney, that you'd better hope that you have taken these things into consideration. All right. Because we discussed a little bit about the difference between morals and ethics, I always like to use a simple moral dilemma at the outset of a discussion. And in this case, you're just a lawyer walking past a large pond on a nice day, and suddenly you hear splashing and you see a toddler alone struggling in the water several yards from shore. You run to the shore, intending to jump in to save the child. But at the waterfront, you realize that you're wearing your brand new $1,000 Air Jordans. So do you stop and take off your shoes or jump right in? I know that, so the reason that this is a moral dilemma is because it balances, we're balancing the needs of protecting humans against protecting property. And when we use this in classroom settings, it's almost always 80 or 90% typically that say that they're going to jump right in. They're not going to worry about their shoes. But the reason that we talk about this is because it's important to understand the perspective of morality as opposed to ethics, which we'll get into another scenario with a combination of the two. So keeping all of that in mind, you want to think to yourself about what you would do under those circumstances. It's not that, there's a right answer and a wrong answer, or that one person is a good person and one person's a bad person. It's just it's just that little voice in the back of your head. What is that little voice telling you? So now we can talk a little bit more about where ethics and morality meet. And we'll talk very briefly about some life and death decisions, because ethics and morality tie in very, very well in this particular area. So I go to my doctor, who happens to have an office at a local hospital here in Boston. I go to my doctor for my annual checkup, and again, in a hospital setting, he gives me great news. I'm in perfect shape. So, my organs are all great. My blood pressure is great. My sight is great. Everything's working, terrifically. And what's interesting about that is that the doctor then says to me, oh, and by the way, we have 5 patients in the next room who need healthy organs, and without them, they're going to die. You have those healthy organs, Tom, and we think it would be a much better idea for us to take your organs and save the lives of the 5 people in the other room at the expense of your life, right? Sort of a parade of the horribles, an absurd example, but you have to think about the connection there. When that doctor is talking to me, there's both a moral question and the ethics that sit on top of the morals that have to be, answered by that doctor. Now, medical doctors and other types of doctors typically have to take a Hippocratic oath, meaning, to do no harm. It's a first do no harm. So, we can ignore that issue for the moment and just say, just think about it as a life and death decision. But for just a moment, think about what your answer, why your answer would be, yes, we should, harvest Tom's organs and save the lives of the people in the other room, or no, unfortunately, we can't. those questions are questions of morality, and again, that's the base, and ethics are built on top of it. So again, just an example for you to consider. So what are ethics specifically? Well, ethics are a standard of conduct, and they indicate how we as lawyers should behave, based upon principles of right and wrong, right? So that example we just used, or the example of the toddler in the lake, or the doctor's example, we really want to understand what are those ethics, and where does ethics start, and where do morals stop? But you can boil most morality down to doing good and avoiding evil, or between right and wrong. Now, your perspective on what is right and what is wrong has to do with everything in your background, your education, your upbringing, your socioeconomic status, the advantages or disadvantages that you've had along the way. So generally speaking, there are areas that we believe are right as a society, and we believe are wrong as a society. Well, as a practical matter, ethics now is how we meet the challenge of doing good or doing the right thing, and that leads us to Model Rule 1.3, and that's diligence, right? And this kind of goes back to that first issue with Rule 5.3 and our AI research. So, under Rule 1.3, a lawyer shall act with reasonable diligence and promptness in representing a client. Sorry. Now, what does that mean? I mean, it doesn't mean that you have to, have your mobile phone on your hip 24/7 and be available, in the middle of the night necessarily. I mean, it might be that you need to be available during the night, in the middle of the night, but you have to make sure that that you're working diligently and promptly in representing a client. And that's a real struggle, right, for us as attorneys, and particularly those of us who have smaller law practices. If when you're in a position where you're representing a lot of clients and you're a sole practitioner, or maybe there's two practitioners and an assistant or a paralegal, in those situations, you got to be really, really aware of the fact that when those calls come in, you have to get back to these clients. I mean, and that trickiness that comes from this is, we also need to make a living, right? And so, we have to, we bring in the amount of cases that we can reasonably handle, and that we can continue to be diligent and prompt with. So for those purposes, just think of the fact that you're getting back to people, and your promptness in responding is almost always the largest aspect of where a client attorney relationship fails. So just keep that in mind. All right. So now that we know a little bit more about morals and ethics, and we're going to go into it a little bit more down the stream here. But what is a profession? We have to identify that. In the early days of, say the early 1900s, there were really two and possibly three professions as we know them today. And it was a kind of a very, snobby approach. And there were three groups that basically were thought of as professionals. First was doctors, as we've described before. The second is lawyers, which, has been a consistent profession for hundreds of years. And also we add accountants into that too at some point, during the 1900s. So those three groups were typically thought of as professionals, and that's not meant to insult anybody. I mean, if there are certainly in our society today, we've evolved where we consider multiple occupations as a profession. So, what is a profession? It's a self-regulated occupational group capable of legally prohibiting others, including incompetent or unethical members, from practicing. Sound familiar? Well, that is why law has always been considered a profession. That's why medicine has always been considered a profession. But today, those concepts extend to. I mean, they can extend to all kinds of different occupations that require licensing or have an independent, group of overseers that are picked by the professionals themselves. That's where we are today. And I think it's very, very important just to understand that you have to be in a position. I'll go back one step. You have to be in a position to understand that we're obviously not the only profession. And now there are dozens of professions. I mean, you could have real estate real estate agents who are, who take an oath under or have to operate under a legally prohibiting or leadership plan or program. So just keep that in mind. All right. Now, rule 1.4. This is a discussion about communicating, and I kind of got into this with our 1.3 discussion, but I think it's very, very important to tie these two together. So the ABA model rule 1.4 is communicate, right? So a lawyer shall promptly inform the client of any decisions or circumstance with respect to which the client's informed consent, as defined in Rule 1.0e, is required by these rules. All right. So what do we mean by that typically? Well, you don't just go in to in my case, as a former prosecutor, I just didn't go into court and resolve a matter without having some approval or putting myself in a circumstance where I had the consent of the people that I was working for. In that case, it was the state. But on the other side of the aisle, now as a defense attorney, it's quite a different thing, because we keep our clients up to date on a weekly basis, and we utilize technology to do that, no matter what, no matter where our client is in the world, and no matter who it is. We always make ourselves available for the attorneys to do a Zoom like this with clients, and the reason is we want to make sure that they're informed all the way along. And if we've got nothing to update them on, then we tell them that, and we let them make the decision of whether they want to have the meeting to ask us additional questions. Now, this is not it's not a question of billing. It's not a question of anything else. I mean, for the most part, these are things that we do out of a sense of duty to the rules, as opposed to something to bill the client for. So keep that in mind. Also, you have to reasonably consult with the client about the means by which the client's objectives are to be accomplished. So there's a tricky one as it relates to AI and or the business environment. And I should mention one other thing, and that is that when we were discussing what a profession is, we are not discussing business, right? We're not discussing all of the business across and the business transactions that take place across the world. We're using business as as an umbrella, so to speak. Where there may be professionals in the environment, and there may not be. But we're going to have an interesting example that we'll discuss in a few minutes. All right. So when you're using AI, or if you're using a system, you have to make a determination if under Rule 1.4, that the means by which the client's objectives are to be accomplished, if you're going to be utilizing AI, you have to make the decision. And it's a difficult decision to disclose to your client. And there may be a host of different reasons why you might not want to. But these rules would suggest that, it's probably a good idea to indicate either in your retainer or in your presentation to a client that, that you utilize the most modern technologies, right? You utilize artificial intelligence. That's just a disclosure that's not going to hurt anybody, and you're going to seem sophisticated, right? If in fact you are using an AI system. All right, 3, you have to keep the client reasonably informed about the status of the matter. Okay, that's again, there's why we do this weekly Zoom check-in with our clients when possible. So you have to make sure that you keep everybody, keep all the wheels moving, so to speak, as you uh, make progress within a case. And that's always tough too, right? And historically, it's always been through, a letter. When I started in practice, 20 some odd years ago, it was, we still used letters. You can send out a letter to a client just to make you're producing paper so that you can show, what it is that you're doing. Well, today's really no different, but there are other modes that we have come to rely upon. One is a situation like this where we're communicating via Zoom or some other virtual platform. On the other hand, we don't typically, and in our practice in particular, we have gotten rid of the paper model. It's just a whole lot. It's hard to change over to it, but once you're over and utilizing a non-paper, where possible, a non-paper based system, things happen a lot faster. You move a lot faster. You're able to communicate more. And so these are some of the advantages that we've gathered as a result of our own change in how we communicate as a practice. Here's where a lot of lawyers fall flat, right? Promptly comply with reasonable requests for information. The worst thing in the world is to have a client that keeps calling the office and they're talking to somebody who's, not their attorney or not an attorney, and they're told, they'll get back to you. Well, it's really, really important to understand that, that the most important aspect of the client relationship is trust. And if you're not going to get back to me as a lawyer, what makes you think that I'm going to, obviously I'm feeling some anxiety, but with whatever the information is that I want or the update that I want. But you should always take the time to do that when possible. And look, we've all had the client that, there's one client out of 10 that takes up 90% of your free time, so to speak. And then the other 9 take up 10%. They don't, they're not rattling your cage. So just keep that in mind, right? That, that you're going to have those situations. It's okay to have those situations. You're going to have to give certain clients more information and keep them more plugged in on certain items if you're going to comply with Rule 1.4. And then also you have to consult with the client about any relevant limitation on your conduct. When the client expects you to do something that is beyond or not permitted by our rules of professional conduct, that's kind of where things tie in it from a business standpoint. And I'll use another quick example. I was a general counsel for a national company based out of Washington D.C. and we had experiences where, and I'm sure there's any of you that have worked in-house or are working in-house understand this, that that the limitations that are put on me as a general counsel are quite different, obviously, than those that are not lawyers. Now, for me, it was always reassuring to have people who had JDs or were actually members of the bar also in leadership positions, because it allows you to speak a little bit differently and to be more clear relative to your responsibilities. And the reason I say that is because in this particular world, right, the world of, we're still in a world of startups, and we're still in a world of evolution, particularly as it relates to, to AI. But let's face it, we're evolving from a technological standpoint, more than we can pretty much keep up with. So I think it's very, very important to understand that, that you're often in a conference room or on a call with people who don't have to live by the same rules that you do. And it's just very important to set that table in advance. The worst thing in the world you can do is, take an in-house position, go to your first meeting and then say, or, your first, second, third meeting. And then on your fifth meeting, say, hey, by the way, I can't, talk about certain aspects of this. I mean, you need to be upfront with people. And if, and you need to make sure that you're, um, uh, you're staying up to date, not only on, on the legal rules yourselves but also making sure that other folks in your environment understand that, that there are certain things that you cannot do and you cannot participate in. Not saying that you should tell people, oh, don't include me so that you can go do something nefarious. I'm not saying that at all. What I'm saying is that there may be other things that are, okay to do in business. They're just simply not okay to do as a lawyer. All right. Now, B, a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation, right? So again, this is where your communication has to meet your audience. If I send a brief designed for the Supreme Court to one of my clients who happens to be, incarcerated, I have to make sure that, I'm not just providing him with the brief, but that he understands what I'm providing him with, right? And so I have to, I always, when I'm doing Zooms with clients, I always go over the information that they reasonably need. And I always go beyond reasonably. I mean, I just give them as much information as I possibly can. But really, you have to make sure that your client is in a position to be able to make these informed decisions. All right. So we talked about what is a profession. Now let's discuss for a minute, what is a professional? Because it's really the professionals, we are where the rubber hits the road, as the colloquialism does. So what is a professional? Somebody who possesses specialized knowledge and skills, belongs to and abides by the standards of a society, and serves an important aspect of the public good. Again, we've used that term "good" over and over again, and it's it's important that it stays in the back of your mind. So, with those things in mind, you can now think through, how the term of professional has evolved, particularly in the past 100 years. There are a number of different societies and a number of different areas of specialized skill that are maybe not considered historically a profession or a professional, but today they are. And so you have to be aware that when you're advising a client who's in a particular, business or industry that requires a specialized knowledge, you should be making sure that your client understands the difference between their obligations, if a conflict comes up between their obligations as a society and your obligations as a member of a legal society. So that is a boiled down version of what is a real professional. All right. Now we get into one of the sticky areas, ABA Model Rule 1.5, and that's fees. So a lawyer shall not make an agreement for, charge, or collect an unreasonable fee or an unreasonable amount for expenses. And you notice the asterisk there. We'll get to that in a minute. Just keep this in mind. As we evolve and as AI becomes more suitable, more accurate, more capable, there's going to be, a real shift in the way we do work, and in some cases, in the work that we do. So you should pay attention to that. Pay attention to your particular industry and your particular legal field, and you should be learning now. If you haven't already, you should be really following what's happening in AI and in legal evolution. The reason that this is so important is because as we evolve into AI, it takes less time to do things. So, if we have more time, we can potentially take on more clients. But you just have to be careful about the concept of, okay, I'm going to charge, I'm charging by the hour, or, And what used to take me 2 days for in the law library or in Lexis or Westlaw, it can be done in 5 minutes. And and it's not okay. Let's be clear about that. It's not okay to go by your old billing standards for that kind of work. If it you know I- if you can get the work done in 5 minutes and you can go off and play golf, that doesn't mean that you get to charge that time to your client because that's what they were expecting, or that's still a reasonable fee. So just watch out for that. All right. Again, and as it relates to fees, this is not comprehensive and only outlines the basic premise of the rule. You got to see the rules for a complete description. And again, I have the proposed rules link in this particular slide and throughout. So we are now going to talk about, and this is where we get to the crossroads of business and legal ethics. So business ethics are very vague, right? An individual as a member of a community has a broader range of issues from top-down principles. So if for instance, you're in a public company and, and the ethics of the company typically will flow from the top to down, meaning, whatever the ethical standards that are utilized by the senior, by the C-suite of the senior office holders, that will trickle down. And it all depends on the kind of industry that you're in. But keep this in mind: if you're a lawyer in any business where there's even a slight possibility that you're going to cross over an ethical boundary, be very, very cautious. And also, it's always better to just be clear. Just be clear and straightforward with the people that you're working with. I can't do that. I can't do this. Nothing wrong with saying that you can't do something in particular, because you can always be helpful in other ways. So professional ethics, on the other hand, as opposed to business ethics, are specific moral expectations specific to the particular group. And these are bottom-up cases. So what does that mean versus the top-down principles of business ethics? It means that our ethics are pretty much made from a reactive standpoint, not a proactive standpoint. Meaning, for the most part, somebody didn't just wake up one morning and say, "Hey, I'm going to write the ABA model rules and write rules for lawyers." It usually, this type of thing happens and rules become rules as a result of some behavior or something wrong that's happened within the community. So it's reactive. So it's not anticipating typically what is going to go wrong. It is expressing what is going wrong specifically. So as those cases come up where there's maybe a defalcation which is a theft of client funds, if there's some form of if something like that happens, right? I mean, ethically you're toast, and the reason is because the legal organizations across the country that are professional overseers have already dealt with those cases. They were brought to their attention, and then they came up with rules to address them. But it's also important to understand that you're not going to be in a position necessarily to be able to to connect those ethical issues. But just keep in mind that disclosure and and there are times when you may have to leave a room, or you can't participate in a particular conversation. And it may not be that it's particularly nefarious, but it might just be something that doesn't, jibe with our ethical requirements. So, one of the examples that I use in my classes relative to this is the example of Gillette World Headquarters, which is of course here in Boston, and it is a very prominent business resident, corporate resident of Boston and Massachusetts. So Gillette World Headquarters, and let's say for the sake of argument that I'm the general counsel. Let's say you are the general counsel of a startup from Cambridge, Massachusetts, which is where Harvard and MIT are, and there's a lot of think tanks and startup organizations that that we deal with on a fairly regular basis. So I use them as the example. And in this case, our startup came up with what turns out to be the greatest recipe for shaving cream, for anyone that's ever been made. It's just remarkable. I mean, it actually cures imperfections in your face, say. Um, you know, and we have sought a patent, and trademarked the issue, but we're waiting in the lobby of Gillette World headquarters, and we're in a few seats around a round coffee table, and we can clearly see in the conference room that the other folks that are competing with us, the other startup that also has a remarkable product, and and they too have sought patents on it. So they are equivalent in some respects, but they're different recipes in the long run. So we're sitting there, and we see the other startup team doing a presentation, providing their pitch, so to speak, that Gillette should buy their technology, buy them out. Now, I'll give you one other piece for context. That is that Gillette's only going to select one. They're not going to buy both of you. So as you're sitting there around the table, you look at the coffee table. The CEO looks down. There's a non-lawyer, and there's a folder on the table that says, secret recipe for Team B, right? The other company. And it turns out that they were sitting in the same seats just a little while before their presentation and before they were called in, and somebody left a folder with their proprietary information in it. And it's very, it's somewhat ambiguous from the outside, but once you open it up and see it, right? But once the person opens up and sees it, they know what it is. Or you either have to close it and put it down, or you have to put it in your briefcase. I mean, and what is, from a business ethics standpoint, it's very, very unclear, right? If my CEO picks up the folder, it's very, very unclear whether or not it would be violative of business ethics. I mean, because let's face it, in business, business has always been described as a jungle. And you have to keep in mind that those business ethics are just not, they're different for everybody. And again, they're coming from the top down. So CEO says to everybody at the table, you're not going to believe this, folks. We have the golden key right here, the golden ticket. And what should we do? Right. Well, if there's 4 or 5 of you, and only you are the general counsel and only you are the attorney, you're going to have potentially very different answer than your colleagues. And I think that that's very, very important to keep in mind, right? So there's a situation which you have to say, hey, look, as a lawyer, and it may not be that it's unethical for you to look at it as a lawyer too, but you better stop and ask the question of yourself and figure it out. And the reason is because if it is unethical, you're going to pay a price for it, almost certainly. And the price is not going to be, one that's well received. So keep those types of things in mind, because that's where the real difference in the pressure of business and legal ethics come together, and they come together in so many different areas too. That's just one example, right? A vivid example of what happens, from a pitch standpoint. I don't know what my answer would be under those circumstances. To the CEO, like what can we do with this, or what should we do with this? I believe, at least from my ethical standards and background, I believe that it would be personally unethical for me to participate in any kind of even accidental corporate espionage. I just wouldn't want to take the chance. So at the outset, I don't say, I just say, look, I don't have an opinion on this at the moment, and I want to make sure that everybody understands. Remember that people, if you don't say it, then people aren't going to, they're not going to recall that, oh yeah, Jenny or Tom, brought that up, immediately that there's legal ethics that are involved here that they can't participate with. So those are the types of challenges that you see, and you see them across industries. You can see them in small practices, the mom and pop pizza shop. Where we are in Boston, there's pretty much a pizza stand on every corner and on every block. And I suppose that's the case for many urban areas. But keep in mind, if you're giving advice to the mom and pop pizza shop, you have to make sure that it's understood, and you have to take into consideration certain things like the ability for people to be fluent in English. So you got to take into consideration, so they're understanding. Do they understand what I'm saying? Can they understand what I'm saying? Am I saying it in terms that are understandable by this particular person who belongs to this particular audience? So that's a very, very important issue to be aware of too. So now we're going to talk a little bit about, this is sort of the last stage of this presentation. So hang in there. Legal ethics versus the law. And this is also an area where, attorneys get into trouble all the time, and you got to think about it. So you have to remember that the laws are not ethics. The laws are what society has created in order to impose its moral compass and duties. So from a legal standpoint, the law is what society says morality, what you shouldn't do if you're going to be a moral person. Now, there's obviously, exceptions to that, but for the sake of this argument or this discussion, let's just go with it. So the law is always going to be more significant and is always going to take precedent over legal ethics, right? And you can get into situations where there is a moral duty to obey the law, but obeying the law might result in you violating the legal ethics. So, those are the types of conundrums that you can run into. And so you got to understand that ethics is a much more, broad professional issue than the law. I mean, the law is typically, it's in a set of books, it's in a set of books behind me. But ethics, on the other hand, requires judgment and discussion and constant thought. So professional ethics is more broad than the law, and the law is not going to be specific about not about defalcation and in a client's and taking a client's resources or money. And remember, you can still be unethical without behaving illegally. You can be doing something that's unethical, but it's not illegal, right? And you can think of some kind of clear and obvious examples of that. And then rarely, ethically, you have to resist the law. So let's use an example. If I am what's the best one? If all of a sudden there's a law that's passed in Massachusetts, and it's signed into law by the governor. I used to deal with that as Comptroller of Massachusetts all the time, and having to interpret, laws both from an ethical standpoint and a legal standpoint. But there are times when legislators will create a law that, that you're not violating by taking that action or engaging that behavior. But you're still under the ethical rules of our profession. So please keep that in mind, that that there are times in which ethically you'd have to do something that's an opposite of the law. If you get in that position, if you find yourself in that position, it's, to a certain extent, it's sort of like the opposite of a Perry Mason moment in your career. You have a few of those things happen over the course of your career. If that happens to you, you should be reaching out to your bar right away, to your particular state bar, and you should be making sure sometimes you have the ability to call in and be discreet without having to identify yourself, and you can just ask a question of one of their ethics lawyers, But just keep in mind that, that those are very, very unique situations, but they happen. I can say that it has happened to me, and since I know that that challenge exists, I think it's important for you to know. All right, so on to the final rule, model rule 1.6, and that's confidentiality. Now, look, this is a lot of verbiage. It's a lot of word salad, but you know you you pretty much know what confidentiality is, right? You just have to understand something. And particularly as it relates to some of these systems that we're talking about from an AI perspective. And what do I mean by that? Well, there are several large AI producers. In other words, companies that have been established within the law for a very, very long time that have put out products that are AI related. One of those products, I'm not going to say specifically what it is, but with one of these products, you can actually upload documentation, your library of documents, into a database in the cloud, right? And then you can utilize the AI technology to scan all of your documentation and all of the stuff that you've uploaded, and find documents for you, find issues for you, and find things much more quickly than if you say, well, I remember working on something like that in 2010, but I'm not sure, I can't remember the name of the parties. So just keep in mind that if you're going to be utilizing these systems and you think uploading client information, if very specific, if you're uploading client information that would be considered private or covered under the attorney-client privilege, then you absolutely must make sure that you that any information that you upload you have to have an assurance that's got and I'd have it in writing from that company that says nobody no kid who works for us is working out of their parents' basement someplace in the corners of Massachusetts. I can't have that kid who's a non-lawyer, who's who's maybe a UX, a user experience or user interface expert. Again, not a lawyer, living in the parents' basement using their computer. Well, if they have access to my documents, that can be problematic. Let me give you an example. If I represent a political client, which we do on occasion, if I represent a political client and I have all of this documentation that might be negative, right? Negative information for my particular client and politician. So I upload all that information, and I use it to download regularly, to scrape it regularly for certain things that I might want to use on a factual basis, etc. So the next concern is if the kid in the basement has access to your documents, and it just so happens that they take a look at the documentation, and they say, wait a minute, this person, whoever your client is absolutely the opposite of what I want to see in a politician or in candidate. So, without really, other than making a promise to his bosses or her bosses, that they're not going to do it, you are on the hook for that. So can you imagine if all of a sudden, you have a national candidate or a statewide candidate or even a local candidate in which that confidential information turns up, because the kid in the basement provided it to your local newspaper, all of it. You're croaked if that happens. And not that, but it's going to be provable because you've created this electronic record of uploading the information. So that's the type of information that can be the type of AI that can be very helpful, but is also very, very dangerous. So think a couple of layers down when you're using this stuff. Think about the accuracy. Where is it drawing its information from? Where is the system drawing its information from? Some of them are very closed universes. They don't use the Chat GPT and the other sort of ubiquitous AI systems that are evolving. So, you want to make sure that the system is closed so that the system, that the AI search is not going and looking for cases that don't exist, for instance. So make sure that you pay attention to that, because again, not only humiliating, but instantly actionable by a court and instantly actionable by a bar. All right. So again, for the record, it's not a comprehensive and only outlines the basic premise of the rule. Please see the ABA rules for a complete description, and there's the link. So we have to make decisions about law and ethics ultimately. And as we've said, law almost always wins over ethics, but not always, right? So it's like Occam's razor. You're in a position where it's not a law, it's a razor. And it happens almost all the time, but not always. And I wouldn't want to come up across that not always, on the wrong side of that, not always. So be very careful not to embark on an exercise in ethical analysis when there's a clear legal rule that obviates the entire process, right? So if you're going to spend your time doing something or advising the client to do something that is going to be illegal, now, obviously, typically we wouldn't do that. I mean, or we probably get disbarred. But it's important to just recognize that the law, because it trumps ethics, you can't just sit back in front of the bar folks and say, well, the law said I could do it. If there's a rule, and and remember, we're self-policing. So if there's a rule, you better pay close attention to it. All right. And then here's where professionals, particularly lawyers, often fail, and it can happen in business too. Here are some of the the key issues: plagiarism, leaking confidentiality of data, fake data, criticizing colleagues for gain, holding back, disguising data, destruction of data, not reporting incidents deliberately, strict adherence to rules where harm is obvious, and that's really described as malicious obedience. That's a Jesuitical term, but that is just you're following the law and you're following the rules, and it's harming other people, but you don't care. You're just obedient to the rule. So these are the areas that you really have to be aware of, where there's a significant difference between what a person in business might be able to do, and think of the plagiarism aspect of AI if you're having it write briefs for you too. I'm not saying that it's plagiarism, but it's certainly not your original work, and that's something you have to take into consideration as a lawyer. All right, now finally, how to handle any ethical question. Again, and this is almost because it's really, again, more of a razor than the law. But the first thing you have to do is take a look at the consequences. What happens if I act? What happens if I don't act? What is you're obviously going to stay on the side of law, but what next? What do you do next? Yeah, you always assume that you have a variety of options, and you consider the range of both positive and negative consequences of each. And then who will be helped by what you do and who will be hurt, right? Let's go back to my doctor example. My healthy example of wanting to take my organs, to save 5 other lives. Again, you will probably hear a voice in the back of your head that tells you what the right thing to do is there. After looking at all your options, which one produces the best mix of benefits over harms, right? So we always, it's just like our legal standards, if you operate in criminal court beyond the reasonable doubt standard, most often then you're on the hook for that scale, right? For to make sure that that you're doing again from an ethical standpoint, in all of your options, you're doing the least amount of harm possible, and then if you're inclined to the most amount of good. I mean, you can start by not doing the bad stuff. All right. And then again, this is it. Time constraints and monetary and political pressure can increase pressures to conduct yourself unethically or immorally. There's one caveat that you don't have time to, if you don't have time to thoughtfully analyze a situation. And that is, you almost know, and this is what I just mentioned before, you almost always know the right thing to do. And almost everybody has that voice, of conscience in the back of their head that says, don't do this or don't do that. If you don't know your options, listen to that voice. I mean, if you're in a position where you have to make a decision this minute, listen to the voice. Because that voice is typically if you're a well-trained lawyer and a well-experienced lawyer, then you're going to be in a position where that all works. All right. And finally, you have one name and reputation. And while folks won't always remember the ethical and moral good you do, they rarely forget the bad, right? I mean, with only one name and reputation, you can destroy yourself, with one bad decision. So keep that in mind. Do good things, and thanks so much for joining us today. And I'll take any questions if people have them.
Awesome. Thank you for that wonderful presentation, Tom. Now we can go ahead and move on to audience questions. It looks like we've already got a couple. All right. Okay, the first one is, considering that ethical rules are reactive and AI is advancing so rapidly, could there be an instance where a new ethical rule related to AI is already irrelevant by the time it's published or accepted?
Oh, that's such a great question, and it really is. And the truth of the matter is yes. I mean, that not only is it possible, but it's likely, right? Because the technology is moving much faster. I mean, think of how, like for instance, the ABA rules, the model rules. They're just that. They're model rules. We think you should live by this, code if you're a member of a state bar, right? And so those model rules, they don't change. They don't change often, and they certainly, there are certainly aspects of modernization that they don't take into account. An example would be, for instance, having non-lawyers participate in the business of practicing law. Right, that's impermissible here in the United States, and it is permissible in other countries like Great Britain, or groups of countries like Great Britain. And so that's a really big issue. That lawyers have been asking for years to be able to do this, and a lot of large law firms, and many of you that are large law firms would understand this. That the large law firm is going to is in this era, the senior leadership is going to be considering, what happens when that rule changes. And, are we going to go public? Are we going to, there are all kinds of different things that, that can happen as a result of that. But that happened in Britain, 10, 12 years ago, and it still has not happened here. So no, the ABA is not particularly reactive. And it doesn't impulsively change any rules.
Awesome. Thank you for that insight, Tom. Our next question is, are there any legal strategies that might be ethically questionable in a business context, even if they are technically within the bounds of law?
It's an interesting question, right? This is a situation where, you could have a legal strategy. And again, if we want to use one of our examples, it might be perfectly legal in certain cases to involuntarily take my organs, right? Not to the point where I die, but they need a kidney, they need a half a liver, so they say I'm healthy, they strap me down at the table and they take the organ and go. Well, you really have to think about, and I hope this is really answering your question, but you have to think about, even if it's illegal, even if something is illegal, you're still in a position where, or legal, you're still in a position where it may not be ethical. Now, it certainly is not going to be ethical for the doctor, right? We know that because the first do no harm is their basic premise, and that would be harming to me if it's involuntary. But you can certainly see areas in which that can happen, and it's it really is it's a challenge.
Thank you. And I think the last question we have time for today is going to be, in cases involving international business and legal matters, what ethical considerations arise when you navigate different legal and cultural frameworks?
Another great question. This is something that we spend a lot of time on in most of my my business courses. Because we're so global and our economy is so global now, that we're now in a position where where we have to interact But think for a minute, like back to an example. I'll use a very, very quick example. A law student working, in my class gets a job with a Taiwanese law firm for the summer as a summer associate. Now do the ethical rules, or let's say that they're a member of the bar, member of the Massachusetts bar, a brand new member. They go to work in an overseas place, and in that overseas place, they determine that wow, there's really not much stricture for a lawyer here, right? I can do a lot of things here that I can't do back in Massachusetts, or there's a lot of stuff that I can't do here that I can do back in Massachusetts. Well, there are not a lot of specific cases on this, but you had better be very, very wise to this. If your bar finds out that that you did something that was, out of the country, out of the jurisdiction, and it still was, from an ethical standpoint, dishonest, and they can punish you just as easily as if you did it, in Massachusetts or in your home state. So, absolutely, you gotta, you have to make sure that you follow the letter of the law of the other country, but make sure that you always have that your ABA ethics concepts on your back. Okay.
Awesome. Well, thank you for all of your insight and your presentation, Tom, and thank you all for your questions. We're almost out of time for today, so I'm going to go ahead and hand things back over to my colleague, Marina, to wrap things up.
Thanks, Nina, and thank you, Tom, and thanks to all of you for being here today. We really hope you enjoyed that presentation and hope you learned something. I know I was listening along eagerly because it was definitely some interesting material and good to know as lawyers out there. I did want to bring up something before we dive into our housekeeping, and that is if you're interested in AI, if you're a little bit curious about using AI in your practice, but you're taking the cautious route or, you're being very cognizant of some of these rules that Tom discussed today, I do want to encourage you to explore the Justia AI Writer. It is a tool available for lawyers taking advantage of our Justia Elevate websites. And with that, we have an AI tool built into the Justia Elevate platform that allows those lawyers to go ahead and use AI to help generate some of the practice area pages on their law firm websites. It generates the page as a Microsoft Word document draft full of disclaimers and things to keep in mind and check out. You can download that, read it, look at it, make sure everything seems accurate, make sure you're ethically comfortable with it, all before it's ever seen by anyone else. And so it's a nice way to get your feet wet and test out, the AI waters and get a little bit of a flavor for how it might be able to help you in your practice. Thank you all for being here today. Thank you again, Tom. Have a fantastic weekend.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.